Okay, welcome to the redo lecture for study units 14 and 15. This was supposed to be the lecture given on week 12, but because of technical issues that happened last week, and I want to thank everybody who tried to alert me to that problem, I decided that I will redo this lecture for the benefit of all students. So let me continue without any further hesitation. I welcome you all to today's online lecture on study units 14 and 15. We are on page 193 of the study guide. Just as usual, what we do is that we do a brief recap of what we have covered so far. As you can see from the slide here, we are in the area of participation, which is highlighted on the far right of your screen there. We will cover chapters 14 and 15, which deal with perpetrators, accomplices, and accessories after the fact. Then next week we will conclude by dealing with attempt and liability for inchoate or uncompleted crimes. Just to cover what we did a couple of weeks ago, we did study unit 12 and we combined it with study unit 13, dealing with the effect of intoxication on liability and disregarding culpability and liability of corporate bodies. Just to remind you, study unit 13 is not examinable, so you will not be asked questions from it for the purpose of your examination, but it could be used and was available for use in assignment assessment. So we will begin from page 193 of your guide, and I want to ask you to turn to page 194 and observe the learning outcomes of the unit. Please make sure that you always observe the learning outcomes of each unit, and make sure that when you test yourself and before you leave that unit to proceed to another, you have mastered the learning outcomes concerned. So the outcomes in this study unit 4 says, when you have finished this unit, you should be able to demonstrate your understanding of the principles relating to participation by, firstly, distinguishing between perpetrator and an accomplice, expressing an opinion, informed opinion, whether an accused can be held liable as a perpetrator, be it according to the general principles of criminal liability or by virtue of the operation of the doctrine of common purpose, which we'll cover shortly, and recognizing a joining in situation and determining the liability of a joiner in. Now, so far, up to this point, we have assumed the situation of X, the accused, acting alone and performing criminal conduct. But as we know, that is not what usually happens in commonplace. In commonplace, in situations of cash in transit heists or robberies of malls or any sort of crime these days in South Africa, especially, crimes are committed in groups. So the question is, how do we deal with those individuals in the group who do not, by their own conduct and state of mind, satisfy the definition of the crime concerned? How does the law prove their liability beyond a reasonable doubt? So we take the situation, for example, of two people, X and Y, decide to rob a cafe. X walks into the cafe, threatens the owner with a revolver, and in this way succeeds in getting possession of the money in the till. Z never goes into the cafe but stands guard outside in order to warn X should she see the police coming. Nobody will deny that X has committed robbery because X, by his own conduct and state of mind, would satisfy the definition of the crime of robbery. But the question would be whether Z can also be convicted of the robbery. Bear in mind that Z was never inside the cafe, never handled the revolver or pointed it to the store owner, and never even touched the money. How then do we deal with the liability of Z? This is what we will more or less cover. And ironically, we are dealing or covering these matters having come from a very turbulent week in this country, whereby there were riots and there was, I prefer to call it theft and not looting. I think let's call it as it is. We'll allow the media to use terms like looting, but we should call it what it is. It was theft, it was housebreaking and robbery, and just vandalism. So in those instances, there were a lot of people, and there are a lot of people that have been arrested. It will be interesting to see what the approach of the National Prosecuting Authority is on the charges concerned, because they were performed in groups. So we are dealing more or less with such situations in this instance. Getting into the unit now, before we, what will be very important here, I want to stress, is that you need to be able to identify your participants or the people that are involved in the crime. You need to be able to say this is a perpetrator, and by virtue of being a perpetrator, his or her liability in terms of this crime is this. Or this person is an accomplice, and by virtue of being an accomplice, their liability is this. So how we do that is that we begin by classifying people in group crime or mob-related crime in terms of persons involved in a crime. Now, the term persons involved in a crime is not a legal term. It's just a convenient terminology that we use to try and explain this classification process that is very, very important in this instance. So we divide persons involved in a crime into two categories: participants and non-participants. And the distinction basically is that participants, or a participant, is anyone who does something whereby he or she furthers the commission of the crime. On the other hand, a person involved who does not participate or would not be regarded as a participant is somebody who does not further the commission of the crime at all. So under participants, we have two categories: perpetrators and accomplices. And under non-participants, we have one particular category called accessories after the fact. As stated, anyone who furthers the commission of the crime is a participant. So the idea here is that these are people that were involved in fulfilling the crime that they are charged with. They are not individuals who come after the crime has been completed already. So a non-participant who does not further is obviously an accessory after the fact. Now, I want to stress, and I'll continue to stress in this section as we go along, the importance of definitions. We are now on page 195 of your study guide. So, sorry, 196 of the study guide. And in 196, we have shaded blocks of perpetrator and accomplice. Now, so far, under the definition of perpetrator, we have two types of perpetrator liability. The first type is the one that we have been dealing with all along, whereby we say the person, by their conduct, the circumstances in which it takes place, and the culpability with which it is carried out, satisfies the requirements in the definition of the offense. So this is X who would unlawfully and intentionally cause the death of another human being, and by virtue of fulfilling that definition in its entirety is a perpetrator liable for murder. So for the purpose of this distinction, I will call this type of perpetrator a perpetrator according to ordinary principles of liability. The second form, which will be more the focus of our discussion in this unit, is whereby the person, although by their own conduct do not comply with the circumstances in the different elements of the crime, they acted together with one or more persons, and the conduct required for the conviction is imputed to him by virtue of the principles related to the doctrine of common purpose. So here, a doctrine is applied to satisfy the missing elements in the different elements of the crime. So, for example, in the case of murder, that would be the case of causation. So in a situation whereby somebody dies and the other person just was a standby, did not shoot, but just kept guard to make sure that there's no intervention or interference from the police. That person, if the principles or the doctrine of common purpose is satisfied, what would happen is that the lacking causal requirement or causation requirement would be imputed from the one who satisfies the definition to him, so that he would also be deemed to have caused the death of another human being. Now, the importance of knowing the definition of perpetrator is that if you know and you are clear in terms of how to define who a perpetrator is, then you will easily identify who an accomplice is, because an accomplice necessarily by definition excludes the two types of perpetrators that we've spoken about. So if you observe the definition of accomplice clearly, you will see that a person is an accomplice if they do not comply with the requirements of liability in terms of the ordinary principles of liability. In other words, not a perpetrator in terms of the ordinary principles, or is not a perpetrator if we apply the doctrine of common purpose. Now, I will explain briefly that there are crimes whereby the doctrine of common purpose is inapplicable. Those kind of crimes are crimes whereby X has to perform those crimes by his own body parts, or X, for example, has to satisfy certain descriptors in the definition of that crime that only X can satisfy. So there are crimes whereby, especially those crimes that are formally defined crimes, or whereby the crimes, what is prohibited is the nature of the act that is performed, not the consequence. So, for example, being in possession of drugs, use or possession of drugs is a formally defined crime. The concept of possession can only be performed by those who possess those drugs. The crime of rape as well, in certain circumstances, whereby there's no gang rape involved. But let's say the instance whereby one of the persons just holds the victim down to ensure that there's no resistance, whereas the other performs the act of sexual penetration. For that person who holds the victim down, that person did not perform an act of sexual penetration, and by virtue of the fact that the act of sexual penetration is only conduct that can be performed by somebody's body parts, particular body parts, that cannot be imputed on the person who merely holds the victim down. So in such an instance, common purpose liability will not apply. However, that person would be an accomplice because they engaged in conduct whereby they furthered the commission of that crime by someone else. And that someone else is obviously the perpetrator. So to make sure that you know the definition of accomplice, you have to make sure that you are clear as to how you identify a perpetrator. Once you exclude who a perpetrator is, then you are able to say that that person engaged in conduct whereby they nevertheless furthered the commission of the crime by someone else, then that person is an accomplice. Now, I want to stress this because it is so easy, or shall I say, those of us who were once lay people, and many lay people would just say that if somebody is somebody's, if Y, for example, is X's sidekick, then we would say that Y is an accomplice. But Y could easily be a co-perpetrator. If we apply the technical definitions concerned. So you need to make sure that you don't just flimsily call somebody an accomplice who could easily be a perpetrator or a co-perpetrator in such instances if they satisfy the definition of perpetrator liability. So I want to stress the importance that these concepts are very technical, and you have to make sure that you master how to utilize these concepts very well. Now, obviously, when you apply perpetrator liability, there are certain keywords that we look for as markers. So, for example, if you want to say X is a perpetrator of murder, because by their own conduct they satisfy the definition of that crime, that's what we'll be looking for. We'll be looking for words like by their conduct, by the circumstances, and the culpability, they satisfy all the requirements in the definition of the crime. Then we will know that you have clearly utilized the definition of being a perpetrator according to ordinary principles of liability. If you say that X is guilty of being a co-perpetrator by virtue of applying common purpose, then there are also words that we're looking for to see that you have clearly applied the doctrine of common purpose. We'd be looking for words like acted with one or more persons, and the act of the one was imputed on the other. So we're looking for, according to the doctrine of common purpose, so we're looking for those key words that you will see in page 196 in bold. And the same thing applies with accomplice liability. There are keywords, crucial words that we're looking for. The person does not comply with the definition. The conduct cannot be imputed by virtue of the doctrine of common purpose, but they nevertheless further the commission of the crime by someone else. That would be how you identify somebody as an accomplice. So you can't just conclude this is a perpetrator, this is an accomplice, without applying the principles and the key words that are in these definitions. Moving right along and just clearing certain terminology out of the way. For the purpose of liability, we don't use terms like direct or indirect perpetrator as such. A perpetrator is a perpetrator irrespective of whether they performed that conduct by their own hands or they used an intermediary to achieve that conduct, whereby somebody, for example, hires an assassin, and Z, for example, being the assassin, is the one who unlawfully and intentionally causes the death of another. But X is the one who hired Z. Now, Z, obviously, in that situation would be a direct perpetrator in that sense, whereas X will be an indirect perpetrator. But in the end, they are co-perpetrators. Their liability will be as perpetrators. And that will be, it is irrelevant, therefore, for purpose of liability, whether you identify a perpetrator as a direct or as an indirect perpetrator, or whether you use words like principal perpetrator and somebody who's not a principal perpetrator. It does not matter how you use those terms, but just make sure that you identify them as co-perpetrators regardless, provided they satisfy the definition of being a perpetrator. Now, before getting to this portion, we cover on page 196 briefly the perpetrator by virtue of ordinary principles. Sorry, page 199. Perpetrator by virtue of ordinary principles. We have done that at length, so I will not dwell on that. So we will move immediately to page 200 of your study guide, where we are talking about a perpetrator by virtue of the doctrine of common purpose. Now, this definition of common purpose is very, very important for you to know. Please make sure that you're able to provide it as is in that gray block there. If two or more people having a common purpose to commit a crime act together in order to achieve that purpose, the acts of each of them in the execution of that purpose are imputed to the others. Now, I want you to notice something about this definition. First and foremost, liability depends on whether you can establish that there is common purpose amongst the group. So in other words, the group concerned must act in common purpose, or the perpetrator that you are assessing must identify themselves with the common purpose of the group concerned. And then obviously they must act together in order to achieve that purpose. There can't be any disjuncture in terms of acting together. And then importantly, it is the acts that are imputed, not the intention and not the liability. Remember, when you use the word liability, you are talking about the act and the intention combined. That is what determines liability. So liability is not imputed and intention is also not imputed. What is imputed is the missing act requirement, or the acts that the one perpetrator would be lacking, that the others would have. That is what is imputed to those who don't have that act. And thereafter, once you say it is imputed, then you determine the intention of that particular individual alone. That person would have either intention in the form of direct intention or dolus eventualis, but that is determined separately from the question of the imputation of the act. Now, the definition of common purpose came from the famous case of State versus Safatsa. In the case of Safatsa, it's the case of the Sharpeville 6. A 1988 judgment whereby members of the crowd stoned and burned the deceased, who was a mayor of Lekoa Township in Sharpeville. However, it was not possible to determine which specific members of this crowd had participated directly in the killing, i.e., which one of them had causally contributed to the killing. So in the event, 6 members of that crowd were identified and brought to trial on charges of murder. Although there was no evidence that they had struck a blow that caused the death of the deceased, they were convicted of murder on the basis that they had made common purpose with the unknown members of the mob who had struck the blows that killed the deceased. So the 6, famously to be known as the Sharpeville 6, were sentenced to death. Their appeal against the conviction and sentence failed on the ground that they had been parties to the common purpose to kill the deceased. However, their death sentences were later commuted by the state president. So in this interesting set of facts, what had happened is that the deceased was the mayor of the deputy mayor of a certain council in the Sharpeville area at the time, and that mayor was known to the residents of Sharpeville as having supported the increase of rates, and members of Sharpeville were unhappy with the decision to increase municipal rates. And so they decided to protest against this particular individual who lived on Nklapo Street in Sharpeville. So they gathered on the adjacent street called Zwane Street and gathered in a group and moved as a mob and came to the entrance or the front entrance of the house of this deputy mayor. The police then came and tear gas and water cannons were used to disperse the crowd. The crowd was dispersed. Then the police went inside, spoke to the deputy mayor, tried to convince him to leave and to find safety. But the deputy mayor refused to leave his residence, to which the police then left where they were, and then the crowd reassembled themselves and went back to their original positions. Now, once gathered again, then the mayor made the fatal misjudgment of firing a shot into the crowd, which struck one of the crowd members, and this angered the crowd. And what then happened is that some of the crowd members went to the next door and they started making petrol bombs, whereby they would take petrol from the cars that were stationary and funnel them into bottles with sand and light them and then give them to members of the mob to throw them through the window of that house. So the house was pelted with these petrol bombs that were made, and the deceased then tried to, or the mayor at the time tried to escape to the other next door, and was apprehended by some members of that mob who beat him down until he was unconscious. One of them had actually a couple of them had actually thrown stones onto the deceased that caused him to be unconscious. They dragged him to his car, which they had overturned, or they had turned sideways and had set that car alight. And what they did is that they wanted to put his body, or his motionless body at the time, on top of the burning car, but then the body just slipped off from that car, and ultimately they set him alight. Then they left singing struggle songs afterwards. And then the police came and the house was burning, the car was burning, and the body had already smoldered. So in the process, 8 accused were caught, but only 6 ultimately were convicted because there was not sufficient evidence in relation to the other 2. Now, the interesting part here is that it was argued on behalf of the accused that the prosecution did not prove beyond reasonable doubt that there was a causal connection between the individual accused's conduct and the result that happened, to which the court responded by saying that that would not be necessary if one applies the doctrine of common purpose. But then the court stressed that what is important is that there must be a demonstration when looking at each individual accused's conduct. We must be able to conclude beyond a reasonable doubt that the accused manifested by their conduct an active association with the criminal design or the goal of the group. So, for example, accused number 1, for example, was identified as the one who had grabbed hold of the deceased between the fences of the houses and had thrown the stone that made the deceased unconscious. Accused number 2 was identified as one who himself had thrown a stone through the window of the house, and then afterwards threw a stone at the deceased, which struck the deceased on the back. Accused number 3 was identified as one who wrestled with the accused to disarm him of his pistol at the time. Accused number 4 was identified as the woman who, after the deceased had fired a shot into the crowd, the woman said, "He's shooting at us. We must kill him." And then at some point when his motionless body was brought before the crowd, and then one of the crowd members expressed sympathy, this particular accused, number 4, slapped that woman. And then accused number 5 and 6 are the ones that were, their conduct basically was that they were just part of the group that had marched to and fro between the various instances, but there was no evidence of any conduct on their part that demonstrated their active association with the group. So they were acquitted. Accused number 7 was the one who had made petrol bombs and was busy distributing to the mob and encouraged them to throw those bombs into the house. And accused number 8 likewise was one of the key instigators that reprimanded some of those people that why aren't they fighting for the community? Why aren't they taking part? You know, he was also the one who also handed out petrol bombs and commanded the mob how to surround the deceased and how to achieve the burning of the house. So, having identified or having delineated each of their individual conduct, then the court concluded that based on their individual acts, they had demonstrated acts of association with the common purpose of the group. And by virtue of that, then the conduct of the group that caused the death of the deceased was imputed to satisfy each of their lacking actus reus or acts. And because they had direct intention, or at least had dolus eventualis, to achieve the killing, they were found to be guilty of murder by virtue of common purpose, and they were each co-perpetrators. So therein was the case of Safatsa, which established the principle that common purpose can be established by either prior agreement or active association. And then the principles were further developed in the case of Mgedezi, whereby another case of mob justice, whereby six team leaders who lived in a certain hostel in a particular room were targeted by a mob because they were considered to be informants at the time. So then the interesting part about the Mgedezi case is that the trial court, instead of separating each of the accused people and identifying what their individual conducts were in relation to what the mob had achieved, brought all of them together and said they were all guilty of common purpose liability, to which the appeal court chastised the trial court in its approach to say that it is important to separate each of the accused and determine what their individual conduct was. And so in relation to one of the accused number 6, we then had these particular principles that came out and were established from Gedezi. So if there's no proof of a previous agreement between the perpetrators, the following requirements for active association liability must be proved for a particular accused to be found guilty based on common purpose. He must have been present at the scene of the crime and must not have been a passive spectator. He must have been aware of the assault on why that is the victim that was taking place. He must have intended to make common cause with the group concerned, and he must have performed an act of association or an act that demonstrates that he or she associates himself or herself with the conduct of the group. And once 1 to 4 or elements 1 to 4 are satisfied, then the imputation principle kicks in, whereby the acts of the group are imputed onto this particular accused. And then point number 5 is the element of intention. You must establish that the person had intention to kill either in the form of dolus directus, dolus indirectus, or dolus eventualis. Now, these particular principles in Gedesi were then later to be challenged in the Constitutional Court in the case of State versus Tiebus. In the case of State versus Tiebus, it was a case of gang violence in the Cape. And so what happened is that a group of people who were tired of the drug dealers in the Cape Flats area moved in a convoy of cars towards the area where the drug dealers were known to reside in. Shots were fired from the drug dealers, and a number of those group members then got out of their cars and fired shots back. But in the process, a 7-year-old child was killed, and then there was another individual who was injured. So the two accused particularly, were found guilty, and their matter went on appeal all the way to the Constitutional Court. So the evidence against each of the accused were such that one of the accused was only found to have his act, so to speak, of association was that he picked up spent cartridges from the shots that were fired by those that he was moving along with. The other was just found to have been, the evidence against them was just merely that he was holding his gun. There was no further evidence that he had actually shot at anyone or fired it. All that had happened is that he was holding it and was just loading it. So on appeal then, their convictions, these particular two accused were challenged in the Constitutional Court to say that the common purpose liability violates a number of rights. Among them are the right to be presumed innocent, the right to dignity, the right to freedom and security of the person because it arbitrarily deprives whoever's convicted with the right to proper due process because it lowers the bar for the prosecution in terms of proving beyond reasonable doubt their liability. So in a judgment written by Justice Moseneke, the former Deputy Chief Justice, the court by a unanimous decision held that common purpose establishes a criminal norm or a criminal standard that is necessary to combat crimes that are performed in group situations. And this is a particularly important societal need. So I just want to read a particular portion of what the former Deputy Chief Justice said in that respect in the case of Tiebus. He said the following, which is of interest. At paragraph 36, I am unable to agree with that the doctrine of common purpose trenches upon the rights to dignity and freedom. It is fallacious to argue that the prosecution and conviction of a person dehumanizes him or her and thus invades the claimed rights. The entire scheme of Section 35 and 12(1) of the Bill of Rights authorizes and anticipates prosecution, conviction, and punishment of individuals, provided it occurs within the context of a procedurally and substantively fair trial and a permissible level of criminal culpability. The doctrine of common purpose sets a standard of criminal culpability. It defines the minimum elements necessary for a conviction in a joint criminal enterprise. The standard must be constitutionally permissible. It may not unjustifiably invade rights or principles of the Constitution. Then he went on to reflect and say that the importance of dealing with collective criminal behavior is what the doctrine of purpose seeks out to achieve. So he says the doctrine of common purpose dispenses with the causation requirement, provided the accused actively associated with the conduct of the perpetrators in the group that caused the death and had the required intention in respect of that consequence, the accused would be guilty of the offense. The principal object of the doctrine is to criminalize collective criminal conduct and thus to satisfy the social need to control crimes committed in the course of joint enterprises. The phenomenon of serious crimes committed by collective individuals acting in concert remains a significant societal scourge. In consequence, crimes such as murder, robbery, malicious damage to property, and arson, it is often difficult to prove that the act of each person or of a particular person in the group contributed causally to the criminal result. Such a causal prerequisite for liability would render nugatory and ineffectual the object of the criminal norm of common purpose and make prosecution of collaborative criminal enterprises intractable and ineffectual, close quote. So in that instance, the Constitutional Court held that the principle of active association was constitutionally compliant with the rights in the Bill of Rights and could not be assailed. So in the case of Tearbus, the doctrine of common purpose was upheld to be constitutionally compliant, and the principles of Mgedezi in particular were found to be sound. The other cases that you also would need to know is the case of Mulimi, but let me get to that. So far we have dealt with the principle of active association ad nauseam. However, let's remember that the other basis on which an accused can be held liable is for common purpose liability is if there is prior agreement, either express or implied prior agreement. Now, it is usually difficult to establish that there is agreement amongst a group of people to achieve a certain result. However, I think it can be fairly concluded if, for example, you have a gang or you have a group of people that are usually robbers of cash in transit vehicles, or a syndicate that robs malls, or a syndicate that is involved in instigating certain violence or certain acts of treason, so to speak. So in all of those instances, for example, you can safely conclude that there is an implied agreement or implied prior agreement to achieve those ends. But then usually what happens, as is the case, is that people go out, perform a robbery, and then in the course of a robbery, someone or some people get killed. Now, in that process, we can say that the robbery or the cash in transit heist was part of the prior agreement. So it was part of the mandate. So it's easy to impute or to use the principles of imputation in those instances. But then what if, for example, there is, as usually happens, a further murder or a further instance that happens which might not have been foreseen or might not have been part of that mandate. How then do we determine the liability of people in those instances? That is where the concept of dolus eventualis then comes in. And I'm now on page 204 of your study guide, where we speak about the case of Mambo and the case of Mulimi on page 205. Those are quite interesting facts, so I will just basically run them down through you. In Mambo, we had 3 awaiting trial prisoners who planned to escape from their court cells. The plan included the forceful dispossession or robbery of the court orderly's firearm. When the orderly unlocked the gate of the cell so that the accused could enter, X1 gripped the orderly around his neck, X2 reached for the orderly's lower legs and tugged at them, causing him to lose his balance, and X3 reached out for the orderly's firearm in the holster and grabbed it with both his hands. As the orderly tried and wrestled to free himself from the clutches of X1 and X2, X1 uttered, "Shoot." X3 then fired the fatal shot and killed the orderly. They were convicted in the High Court on charges of murder, robbery in terms of the firearm, and escape from lawful custody. The Supreme Court of Appeal upheld their convictions on all 3 in respect of the robbery and escape charges, because these were part of their prior agreement. Remember the concept of mandate. It was what they agreed to. They agreed to execute a robbery and to escape. So it was easy to impute the conduct of others in relation to common purpose for robbery and escape charges. But it held that the killing of the orderly did not form part of the mandate. It therefore had to determine whether the initial mandate had extended to include the murder of the orderly. The court held that by his conduct and culpability, X3 satisfied the requirements for liability on the murder charge. However, for his conduct to be imputed on X1 and X2, the court had to establish that each of them foresaw the killing of the orderly as a possibility arising from their conduct and reconciled themselves to that possibility. So basically, X3 was found to be a perpetrator by ordinary principles. He unlawfully and intentionally caused the death of the orderly. But X1 and X2 did not so do that. So in order for them to be held liable for murder, the conduct of X3, meaning the causation element, had to be imputed to cover X1 and X2. So in order to impute that conduct, they had to prove that X1 and X2 individually had dolus eventualis to achieve the killing of the orderly. So X1 was found to have had dolus eventualis or to have shared that common purpose because he uttered the word shoot. But X2 was only found to have grabbed the orderly by the legs, and on that basis an inference could not be made that he had foreseen the result of the killing and had reconciled themselves with that. So his liability for murder was, he was acquitted of murder. Now in Mulimi, the principle was given that if the conduct of one member of the group differs from the conduct that was envisaged or that was planned as part of the mandate, then that conduct may not be imputed on that particular individual unless each foresaw or knew that the death will occur and they reconcile themselves with that possibility. So the words knew is dolus directus, and the words foresaw and reconcile are dolus eventualis. So in the facts of Mulimi, which is another interesting case involving the robbing of the Click store, X1, X2, and Z were co-conspirators to a planned robbery of Clicks. X1, the store manager, informed X2 about the exact time at which the security guard would arrive and collect the money. So X1 encouraged X2 to employ the services of 4 armed men, and Z came with 3 of those unarmed men. They dispossessed the security officer who came on the day in question and fled with their loot. As they fled, there was an exchange of gunfire between one of the robbers and the store security guard. They were both fatally wounded in the exchange. The gunfire attracted the attention of a bystander in the shopping mall, and as the 3 robbers ran towards the direction of the exit, the bystander started shouting at them, and then he drew his firearm and pursued one of the armed robbers, being Z. And Z is the one who was carrying the stolen goods. Z then dropped the bag he was carrying and ran into another store for refuge. Once inside the store, Z turned around and pointed the gun at the bystander, who reacted by shooting at Z. The bullet missed Z but wounded an employee in the store. Z then retreated further and took a young man hostage. While holding the hostage, he ordered the bystander to surrender the firearm. The bystander fired a shot, but unfortunately it fatally wounded the hostage, and then Z eventually surrendered. Now, in those instances, X1, X2, and Z, who were eventually caught, were all charged and convicted on 7 counts, namely the robbery, the murder of the security guard in the exchange that happened when they were escaping, the attempted murder of the employee who was wounded in another store, the kidnapping of the hostage, and the murder of the hostage held by Z. Now, X1 and X2 then appealed to the Supreme Court of Appeal against their convictions. They conceded the existence and proof of common purpose to rob the store, but argued that the actions of the bystander, which resulted in the kidnapping and the death of the hostage, and the injury to the employee in the other store, were not foreseeable by them as part of the execution of the common purpose. In other words, they were not part of the mandate or the prior agreement. The court held that the attempted murder of the employee in the other store was foreseeable, for once all the participants in a common purpose foresaw the possibility that anybody in the immediate vicinity of the crossfire could be killed, then they had dolus eventualis. And you remember in the case of Mulimi as well, it would ring a bell that during a crossfire exchange between the police officer, Derek, and one of the and the robbers, what had happened is that an innocent person was struck and killed by the gunfire of the police officer. And the question was whether the accused concerned could be held liable for the murder of that innocent victim who died at the hands of the shot fired by the police officer. So the court in Lungile said, once people with a common purpose go in with ammunition, they foresee that anybody in the vicinity could be killed by crossfire in the midst of an exchange or in the midst of an effort to escape and secure what they had stolen. So dolus eventualis was present in relation to the killing, or so the attempted murder of the employee in the case of Mulimi. Now, the court then went on to say that, however, the kidnapping of the hostage by Z and the eventual murder of the hostage by at the hands of the bystander in the other store were acts that were so unusual and so far removed from what was foreseeable in the initial mandate that these particular acts could not be imputed to X1 and X2. So X1 and X2 were therefore acquitted on the charges of murder and kidnapping in respect of the hostage incident. So this is where the principle comes in, that conduct that differs from the conduct in the mandate or what is foreseeable in the mandate may not be imputed on the others unless it could be proved that they had intention, either in the form of direct intention or in the form of dolus eventualis. Now, usually these things you can reason them through if, for example, in the set of facts, it is said that, you know, X1 knows that one of his co-conspirators is a very erratic person who just cannot handle the use of a firearm properly, is somebody who gets easily tempered, losing their cool, and is prone to fire. If then they go along, despite that knowledge of the personality of his co-conspirators, and somebody dies in the process from a shooting that happened as a result of this particular individual, X1 cannot turn around and say that, well, I did not agree to, or I did not foresee, I did not agree to the killing, or I did not foresee that the death of the victim would be part of the common purpose involved. He can't say that because he would have be deemed to have foreseen the possibility of that happening, and would be deemed to have reconciled themselves with that possibility if they proceed, nevertheless, with what they knew or foresaw. Now, this portion, the concept of withdrawing from a common purpose, is something that we encourage you to read only for assignment purposes. It will not be examinable, but it will be very interesting to know how, for example, just as much as it can be impossible to prove that somebody was part of a common purpose, it can also prove challenging in certain instances to establish that somebody actually withdrew from a common purpose. The principle being, in short, that the deeper you go into an agreed plan and an agreed endeavor, then more would be required from you to establish that you actually withdrew. And that more could also involve you sabotaging your co-conspirators. That more can involve you maybe, informing the police or other people to just intervene and prevent that from happening. The question is obviously one always of degree. But importantly, the other thing is that the withdrawal must be voluntary. It must not be a situation whereby you are seeing that, well, the cows are coming home the chickens are coming home to roost and will be caught soon enough, and then you do something out of pressure, having seen that would be too late, and the courts would not regard that as a voluntary withdrawal. Now, we are on page 208. And so far, what we have been talking about is the situation where people are involved before the crime is committed, in terms of having contributed one way or another in furthering that crime. But what happens in a situation whereby somebody involves themselves in maybe gang violence, and their participation does not contribute causally to the death of the victim, because the mortal wound was already inflicted on the victim by the group of people.
Mr. Ramosa?
And those that group, yes.
Can you just repeat
Hello?
the last sentence, please, because you disappeared?
Hello, yes.
Can you just repeat the last sentence?
Okay, which sentence, Professor Molema?
Just the last bit, Mr. Ramosa.
All right. We are now at the stage of joining in. So what happens in a situation where an individual participates at a time where fatal wound has already been inflicted on Y, but Y is still alive at the time that this individual participates in this individual commits an act that does not contribute causally to killing Y, because Y died from the original wound inflicted by those who acted in common purpose. As happened in the case of Mutaung, for example, whereby another instance of mob violence at a funeral, whereby this group attacked this particular lady who was the partner to a police officer at a funeral. And in the process, what happened is that this particular accused was found by the court not to have contributed causally to the death of the deceased, because the mortal or the fatal wound had already been inflicted by that initial group, an initial beating. But that individual performed an act that demonstrated that the person had intention to kill that person if they had the opportunity. It just so happened that their conduct did not contribute causally to the death of the deceased. In that instance, that particular individual will be known as a joiner in. And the requirements of joiner in liability are on page 209 of your study guide. A joiner in is a person whose attack did not hasten Y's death, whose blow was administered at a time when Y was still alive, and who did not act with a common purpose together with the initial perpetrators who inflicted the mortal wound concerned. So in the case of Mutaung, the appeal court held that a joiner in could only be held liable of attempted murder, and reasoned that the criminal law is firmly opposed to liability based on after the fact or ex post facto responsibility, does not recognize it in any other situation, and it would therefore be contrary to accepted principle to recognize it in the situation of a joiner in. Now, as indicated, those are the requirements of the joiner in. You have to, before you can say somebody is a joiner in, you have to make sure that these three requirements are met. The injury must not hasten Y's death. The victim must still be alive at the time when the participant inflicts their particular wound, and there must not be a previous conspiracy or common purpose with the initial people who inflicted the fatal wound. Now, that brings us then to the end of the question of liability for common purpose. But before I get onto this particular exercise, I think it's important that I cover the issue of accomplice and accessory liability briefly before we get to this self-assessment exercise, which involves those other aspects as well. Now, study unit 15 deals with accomplice and accessory after the fact. We have briefly introduced you to the definition of an accomplice in study unit 14, so I will not delve much into that. You know what the definition of accomplice is, but as I stated briefly in my intro, there are crimes, and particularly these crimes are what we call formally defined crimes or circumstance crimes. Many of those crimes, because they focus on prohibiting a certain type of act, which could only be performed by somebody's own hands or own body parts, or the additional elements of those crimes refer to a particular descriptor. For example, only a medical doctor or a person who owes allegiance to the Republic can actually be liable for any of those crimes. Many of these crimes would not, for example, be amenable to the principles of common purpose liability, because it is required that the act be performed by the person's own hands or own body parts. And that would include crimes like possession of drugs. That would include crimes like common law perjury. That would include instances of rape whereby there's not gang rape, but there's an instance whereby, for example, as I said in the example, X is the one who committed the act of sexual penetration, but Z is the one who held the victim down to ensure that the victim does not wrestle or successfully repel the act of sexual penetration that will be perpetrated by X. In those instances, the act of sexual penetration obviously would not be amenable to imputation. In the case of Z, who just held the victim down. So in those instances, though the Z, for example, would not be a perpetrator, but would have committed an act that furthered the commission of the crime by the perpetrator or the main guy concerned. So in those instances, the elements are discussed fully in study unit 15. A person can become an accomplice in any of the ways whereby they aid or they counsel or they encourage or they order or they perform any sort of act which furthers the commission of the crime but does not meet the definite elements of the crime concerned for them to be a perpetrator. What is of interest here is that when we talk about the intention element in particular, the accomplice and the perpetrator need not act in mutual conscious cooperation. So in other words, the accomplice can perform the act of furthering the crime even if the perpetrator is not conscious of the assistance that he had from the accomplice. So there need not be any mutual conscious cooperation between the perpetrator and the accomplice concerned for there to be liability. We also say that accomplice liability is accessory. This means, as you have seen in the definition, there has to be a perpetrator for there to be an accomplice. Because the accomplice must further the commission of the crime by the perpetrator. Somebody cannot be an accomplice to their own crime. They must further the commission of the crime by somebody else. So, for example, looking at some of the examples that are indicated on page 215, we see the case of Pecan and Lalu. The conduct forbidden in the definition of the crime was the purchasing of unwrought gold. Lalo bought the gold and was thus the perpetrator. Pecan did not buy the gold, but acted as an interpreter, advisor, and surety in connection with the transaction. Consequently, his conduct did not comply with the definition of the crime, but he nevertheless furthered the commission of that crime by Lalu. So in that sense, he was an accomplice. In the case of Kazi as well, that's there, the forbidden conduct was the holding or organizing of a meeting without the necessary permission. Kazi did not hold or organize the meeting, but was a speaker at that meeting. So Kazi was held to be an accomplice because he did not satisfy the requirements to become a perpetrator. Interestingly, there's the case of Williams. It was decided in the 80s before there was a fleshing out of the principles of the two-stage principle of causation in the case of Daniels. So Williams was decided in 1980, whereas State versus Daniels and the later case of Muketi were decided from 83 and 1990 respectively. So in Daniels, the two-stage approach to causation, meaning factual causation and legal causation combined, was not yet settled by the time Williams came into the picture. So in Williams, we have the interesting dynamic whereby somebody was held to be an accomplice to the crime of murder. Now, murder is the unlawful and intentional causing of death by another human being. Now, if somebody, for example, holds the victim to enable another perpetrator to actually kill the victim, that person who holds the victim causes the death of another human being by their own conduct. So Steyman raises this argument to say that it is not possible for one to be an accomplice to the crime of murder because the concept of causation in and of itself would cover somebody who aids or assists somebody to achieve that. In other words, you cannot further the commission of a crime without causing it. That's the interesting argument that Steyman poses to say that there cannot be accomplice liability to the crime of murder. Accessory after the fact, on page 217, there's the definition of accessory after the fact. We have explained that accessory after the fact is not a participant because they do not further the crime. They only come in the picture after the crime is committed. And importantly, they help the perpetrator or the accomplice to evade liability. Make sure that you understand the definition concerned. And as with the case of an accomplice, an accessory after the fact, their liability is dependent on their being a perpetrator. So interestingly, the principle goes that you cannot be an accessory after the fact to a crime that you yourself have committed. That principle seemed to be fairly settled until the case of Ghani and the case of Jonathan, which are on pages 218 of the guide. In this interesting set of facts, respectively, there were three people. I'll focus here on the Jonathan case. There were three inmates that were brought into a cell, and they were brought into a cell with another inmate. There was already another inmate that was in that cell. What then happened in the evening concerned is that there was shouting and screaming, and then silence. And then when the warder came in to check what was going on, they saw that a body was covered with linen on the floor of the cell and was obviously motionless and dead. The court was unable to, on the charge of murder, the court was unable to establish who amongst that group of individuals killed the person concerned, and the court was also unable to establish beyond a reasonable doubt that there was common purpose to commit murder. So in that instance, the only evidence that the court had was that all three of them attempted to conceal the murder by giving various alibis. One of them said, for example, that the guy inside was already deranged, had an epileptic fit, and died out of that. The other corroborated that evidence as well by the first one, and then the other gave a different evidence, so to speak. So all of them performed acts that were intended to conceal the true perpetrator of the crime or perpetrators of the crime concerned. So they performed an act that was intended to enable the true perpetrators to evade liability. So despite the absence of establishing who the perpetrator was, the court concluded that all of them were liable as accessories after the fact. This was decided in the case of Ghani, and then in the case of Jonathan, that principle in Ghani was challenged to say that one cannot be an accessory after the fact to one's own crime. The court in Jonathan, by a majority of 2-1, decided and concluded that, well, we should regard Ghani as an exception to that principle, that one cannot be an accessory after the fact to a crime that they themselves committed. Now, as I reflected on preparing about accessory liability, I then thought to myself about the mysterious case of Senzo Meyiwa, the former Orlando Pirates and Bafana Bafana goalkeeper, who died mysteriously at the home of the mother to Kelly Khumalo. It is known that there were witnesses in that house, at least 7 of them, and to this day, for example, we don't even know who in particular killed Senzo Meyiwa, and there are accused people that have been brought to court. Some of them, for example, were already serving sentences and time already in prison and are deemed to have been the orchestrators around this failed robbery. But for the purpose of this lecture and talking about accessories after the fact, it then came to my mind to say that why didn't and couldn't the NPA have taken all of those witnesses who were in that house and charged them for accessory liability, because they surely at least had a duty to report or to inform the police as to who actually killed Senzo Meyiwa. And couldn't it be possible, given the authority of Ghani and the authority of Jonathan, to say that, well, we may not know who actually killed Senzo Meyiwa, but surely we can say that their failure in not telling the police who actually did that, and all efforts that they are doing to conceal the true nature of that crime, they have performed an act that enables whoever is the perpetrator and whoever are the accomplices involved to evade liability. And on that basis, they would be accessories after the fact. Couldn't the same principles be invoked in that respect? I just thought that was a very interesting aspect to just reflect on and to think about, given what was held in Ghani and Jonathan. Now, with that, please make sure that you get the definition of accessory after the fact correctly. The involvement must be after the commission of the crime, and it must be achieved with a certain intention to enable the perpetrator or the accomplice concerned to evade liability. I've just briefly spoken about the concept that you cannot be an accessory to a crime committed by yourself, but then there's the case of Ghani and Jonathan. The other question that is interesting to ask, obviously, is whether the crime of accessory after the fact is necessary, because we do have the crime of defeating or obstructing the course of justice. All instances whereby somebody can be guilty of being accessory after the fact are also instances of defeating or obstructing the course of justice. So that's just a very interesting academic reflection to think about in that respect. So with that being said, this brings us to the end of the lecture as far as units 14 and 15 are concerned. I'm now going to go back to the self-assessment question. And we're going to show you briefly how these principles are to be applied. So here we have A is the leader of a drug syndicate. Y, a member, decides to sever his ties with the syndicate and to join another syndicate. Avenging the defection, A cuts Y's throat. Mortally wounded, Y collapses. B, who previously had supplied drugs to Y, appears on the scene and, furious because Y owes him money, shoots Y in the stomach. B had not agreed beforehand with A to kill Y. The bullet wound does not hasten Y's death. Y dies as a result of the wound to his throat. A needs help to get rid of the corpse. For this purpose, he calls in the aid of C, who had agreed before the murder to help A to get rid of the corpse, and D, who had no such agreement with A. So together, they drag the body to a secluded beach and dump the body in the ocean. Now, before you become very flustered with all these letters that just appear in this set of scenario, the advice is go to the questions first and find out specifically what you're being asked to consider. So, isolating the questions, we have the first question says, briefly discuss the criminal liability of B, referring to authority. Then you would go back to the scenario and check where B got involved. So you will notice that B got involved at a stage where a mortal wound had already been inflicted. So he appears, and based on his own motives, he shoots Y in the stomach. B himself did not acted independently of A, did not agree with A, so there was actually no common purpose between A and B to kill Y. But importantly, when B acted, Y was still alive. But nevertheless, the bullet wound that he inflicted did not hasten his death. He died thereafter as a result of the wound to his throat. So the question is, when you have a situation then where somebody's conduct did not hasten or contribute to the death of the victim, that person did not have common purpose with the initial perpetrators who inflicted the mortal wound. And furthermore, when that person acted, the victim was still alive. Who is that person? That person is a joiner-in. And you will see the requirements of joiner-in liability that are indicated at SG 14.3.5 of the guide. Now, in order to get your good 4 or 5 marks, you can't just say that person is a joiner-in and then leave it there. You would say that person is a joiner-in because the bullet wound he inflicted did not hasten Y's death. Y was still alive at the time when he inflicted the bullet wound. There was no previous conspiracy or a common purpose between B and A. So in that respect, B is a joiner in. What would be his liability? His liability is that he can be convicted of attempted murder based on the Motown decision, because to hold B liable for murder in the circumstances would amount to holding him responsible for ex post facto acts. So acts, retrospective acts. That is how you'd get your 5 marks. You'd get your marks from not only giving the answer in terms of who the type of participant is, but in terms of having used the principles of law to identify that participant. And then go on further to rely on authority to determine what the nature of that participant's liability is. The next question for 2 marks, discuss the criminal liability of C. You go back to the circumstances, ask yourself, all right, where does C come in here? Well, C comes in here having been called by A to aid A to get rid of the corpse. Now, what's interesting about C's participation here is that he had already agreed before the murder to help A to get rid of the corpse. So there was actually a prior agreement that he involved himself in, which may have actually even inspired and encouraged A to do what he did. So with those facts covered, B is certainly not an accessory after the fact, because B had agreed beforehand, before the murder, to help A. C would be in that instance a perpetrator, because his conduct complied with the definition of being a perpetrator in that sense of helping A commit the murder. But then again, if you are relying on the Williams case, you could also say arguably that C is an accomplice, because that is the case authority that currently stands until it is literally repealed. And then the last question, dealing obviously with D, is that D came in, he did not have any agreement with A. He just came in to assist A to evade liability by disposing of the body. So D in that instance would be an accessory after the fact, and he complies with the requirements and the definition concerned, as you can see in that answer below. So I want you to see, and I want you to stress, that the definitions that have been given to you have not been given just ordinarily for your entertainment. They are given in shaded blocks for your use. So you can't say someone is a perpetrator by virtue of common purpose, but not define common purpose, not give case authority where you rely on the definition concerned, not say that that person is either a perpetrator by prior agreement or active association, and therefore the act of the co-perpetrators are imputed to satisfy that person's missing conduct. And furthermore, say that that person had intention in the form of dolus directus or dolus eventualis in respect of that crime. And on that basis, with having established both the unlawful conduct and the culpability, together, that person is liable as a perpetrator for the crime concerned. You cannot also say the person is an accomplice without excluding him as a perpetrator, either by ordinary principles or by the application of common purpose, and saying further that that person nevertheless furthers the commission of the crime by somebody else, and therefore that person is an accomplice. And likewise, you cannot say somebody is an accessory after the fact unless you establish that that person came in after the commission of that crime and engaged unlawfully and intentionally so in conduct intended to enable the perpetrator or the accomplice to evade liability or to facilitate their evasion of liability. With that being said, that brings us to the end of the lecture for current purposes. I will now proceed to take questions. I see that the numbers may have gone down. I just want to clarify if the lecture was audible for everyone concerned. Can I see at least by an indication if the lecture was audible for everyone concerned? That's very, very important for me. Thank you very much. I really do appreciate that. I appreciate your confirmation and the affirmation. Thank you. Thank you. I also want to apologize for the disturbances in audio that may have occurred because of cell phones ringing in the background. Let me proceed to okay, all right. For everyone who raised their hands because they wanted to just confirm or to give me confirmation that the lecture was audible, I appreciate that. Can I kindly ask you to lower your hands? And for those that are asking questions, please keep your hands up. Okay, so now I assume that the hands that I'm seeing are those that are asking questions. So let me start with Lituma Bosaleti. Lituma Bosaleti, you can unmute your mic and speak.
Thank you, Mr. Ramos. Yeah, I've got two questions here. I just want to know about three questions. First one is only study clarity in terms of study unit 3. It will only study unit 3. It won't be there for the exam, and also the disassociation or withdrawal from common purpose. Is that the only section that we should not really worry for the exams? And also that's the first thing. The second thing is that on the joiner in, what you mentioned, the issue of that the blow must somehow be administered when Y is still alive. Then if maybe Y is dead, then someone maybe someone is dead and you cut the head of someone who's already dead. What kind of a crime that will be? And also, thirdly, which is my last question, I'm looking at the issue of the state witness. If someone becomes a state witness now, and which means he withdraws from the crime, so he cannot be seen as a withdrawal. Thank you.
Okay. Okay. No, thank you. Thank you for those very, very good questions. Let me start with the first one. Study unit 13, and indeed the study unit at the beginning where I think it's unit 1, where we talk about theories of punishment. And then the section that I've spoken about in terms of dissociation or withdrawal from common purpose. Those portions need not be studied for the exams. It was always open for us to use them for assessing you in the assignments, but we have not done that. So you can virtually conclude that you don't need to study theories of punishment. You neither need not study disregard of culpability, that is study unit 13, and you don't need to study dissociation or withdrawal from a common purpose. Those are the clear sections that you can already note that you need not study for purpose of preparing for the exam. The second question is something that we will cover when we deal with attempt liability next week. If X, for example, commits an act on a corpse, for example, or the intention to kill cannot be fulfilled because the object of the murder is a corpse. It's not a live human being. That person can still be guilty of attempt liability, and we will discuss the form of attempt next week and the principles concerned in holding that person liable for attempt. Can you repeat the third question there?
It was about the state witness to withdrawing. Can you deem in terms of withdrawal? Someone maybe say, no, I'll become a state witness, and so can you also think that of as withdrawal or something like that?
Okay, no, thanks for the question. No, it is not a withdrawal, because at the stage where the person decides to become a state witness, that is governed by the provisions of the Criminal Procedure Act, and that person would already have been part of the crime concerned. So in other words, the person did not withdraw during the stage in which the crime was still being perpetrated or was still to be fulfilled. That person is just becoming a state witness because they actually admitted that they themselves were part of the crime. Does that answer your question?
Thanks, you have answered me.
Okay. All right, okay, I see the question saying that the exam will be MCQ. I may not have seen that. But if indeed that is the case, then it's used. The point of the matter is that an MCQ, by the way, still there will be questions that require you to apply your knowledge. So in other words, just because it's an MCQ does not mean that it is not open for us to ask questions of application. It is the kind of MCQ that gives you options from a scenario. So if indeed that is the case, then you still have to know how to apply the principles concerned and recognize those principles from the scenario in order to be able to select the right option in your MCQ question. So I want to make it very clear that if indeed that is the case, that a communication was made that it is MCQ, which I will not deny, I cannot confirm or deny at this moment. Go with what's communicated on your announcements. If that is the case, please note that an MCQ does not mean that we will not be able to test the ability to apply your knowledge from a factual scenario. Yes, I see you have a question on purpose, Clive. Clive, are you able to get onto the audio platform? Okay. All right. All right. Oh, there, I see your hand there. Clive. Clive, your hand just disappeared from us. Okay, I don't see any further hands, but can I just assure everyone that for those of you that are still waiting for your assignments to be returned back to you, they are still in the process of marking, and you will get your results certainly before the end of this month. Before the 30th of July, you will get your results. I want to assure you of that. Okay, let me just, I see a hand here from, okay, and then we will have a lecture again next week whereby we cover the last unit. And then please be on the lookout afterwards, whereby we will talk about revision lectures that we'll also give. And these revision lectures hopefully will be lectures that you are able to test your ability to not only know certain things that you need to know, but also how you apply them, where you need to apply them. So those are, okay, I see the hand of Dawn Khadebe. Dawn, you can unmute your mic. Dawn Khadebe. Dawn Khadebe, you can unmute your mic. I see your hand. You are Dawn, your mic is on. Hello, Dawn. Okay, all right. I see the hand of Clive as well. Clive, you can unmute your mic and speak.
Hello, sir.
Hi, Clive.
My question on the doctrine of common purpose is that if, let's say, we can apply it to, okay, my first question is that can it be applied to the crime of, let's say, fraud and theft? And then secondly, on that topic, if, let's say, X and Z have the intention to defraud Y, and then Z.
Okay, Clive, can you just hold a bit? Dawn, can I ask you to mute your mic, please? Okay, I'm having problems here. Dawn is not aware that her mic is on. Okay, okay. Thank you, Dawn. You have muted your mic. Clive, you're on the platform. You can speak.
Oh, as I was saying, if, for instance, let's say X instructs Z to commit fraud against Y, can both X and Z, let's say they commit the fraud, let's say X commits the fraud on the behalf of Z, and let's say the theft comes in the form of monies. So can Z also be charged with that fraud on the strength of the doctrine of common purpose, even though we cannot say that Z's conduct complies with the definition of fraud? That's all.
All right. Well, I think it's fair to say that the person who did commit the act that amounted to a misrepresentation would be a perpetrator of fraud by virtue of his own conduct and circumstances and capability. So in other words, that person would comply with all the requirements in the definition of that crime. With relation to X, who I think by virtue of their agreement, it could be said that the act of Z is perpetrated, but I don't think so. It hasn't come across. I'm not aware of a case whereby somebody who just maybe sent somebody to do something would be imputed in that respect in terms of fraud, because fraud does require that that person perform an act which amounts to a misrepresentation. So if one of those people did not perform any act, whether it be by commission or omission, then that person could not be a perpetrator for fraud, but at best could be an accomplice to the crime of fraud.
Okay, I think I understand.
Do you understand that?
Yes, sir.
Yeah. Okay, I see the hand of Sune. Sune, you can unmute your mic and speak.
Afternoon, sir. Can you hear me?
Afternoon, Sune. I can hear you clearly.
Thank you, sir. I want to ask a question linking to what the previous student asked. It's regarding a fraud scenario. So in my place of work, we work with a lot of money, and there was a person, let's call him X, who committed fraud on our systems and stole a lot of money. But it was on Christmas Day. And so nobody's really working on Christmas Day. So he arranged with the guys that's servicing our printers for some of their clothes, and they were in on the deal, and they also benefited from this fraud, as well as the security people downstairs who opened the doors for the so-called printer guys, which came in so that this guy then committed the fraud on Christmas Day on the systems. So the printer guys and the security guys, were they were in on the deal, even though this was fraud. If they did not open the door for him, and if the printer guy didn't come in, then that guy couldn't commit the fraud. So it's a bit of a difficult scenario. But in that instance, the main issue was the fraud that was committed, but there were people that helped him to get into the building, to the computer, to enter the details to commit the fraud.
Okay. All right. Let's see. How far is that case, or are you aware if they were all caught?
Well, from the employer's side, obviously we took steps with our employee, and he was dismissed. In case went to CCMA, he lost the case, obviously, and they're still in the process with the criminal case. So yeah, you know, the criminal cases takes very long, so there's no outcome on that yet.
Oh, okay. Because it is certainly important that there be an act or a proof, an established act, either in the form of a positive conduct or an omission whereby a legal duty to act positively was required. And that must constitute a misrepresentation. So when you look at the definition of what fraud actually requires, there are some who could be perpetrators in that incident, but there definitely will be others who would not be and cannot be perpetrators of that situation. But if they benefited, they would be guilty of theft, because remember, theft is a continuing crime. So if they appropriated the monies from the fraud, they would be guilty of theft.
Okay,
Yeah.
thank you, Terry. Yes, that's clear, because they did not commit the fraud themselves, but they
Yes.
assisted this guy to enable him to get a lot of money, which is not his, and he shared with them. So
Yes.
then for them it would be theft,
That
because
would
they
be
were not the
theft.
ones that pressed the button on the computers to transfer that money.
Yes, indeed. That they would be guilty of theft, or at least receiving stolen property knowing that it is stolen.
Okay, thank you, sir.
Okay. All right. I think I have covered all the questions that have been asked. All right. And then I will say I will try my best to answer all the queries that are on the chat whenever I'm able to. Please, I would humbly request that you bear with us. It has been a very, very busy period dealing with early completion students and the exam that happened recently in the June and early July situation now. So we are trying our best to make sure that we answer all queries. we service our students as much as we can. Where we are unable to answer within maybe 48 hours, you are welcome to come back to us, maybe remind us again. We will definitely get to you. So I'd like to apologize profusely whereby you've had a query sent to us or any one of us, and it just took too long for it to be attended to. We asked, I ask on behalf of my colleagues and all of us concerned that please bear with us, but please do not stop sending those queries. Please do not stop engaging. We benefit a lot from your engagements. We benefit a lot from your questions. It also extends and stretches us. So we are all learning in this process as we go along. So next week, I look forward to engaging with you again when we will finally get to the last unit, which is also an interesting unit dealing with attempts, incitement, and conspiracy. So thank you very much for your patience. Thank you very much for engaging in the lecture and even the questions that you've asked. The recordings will always be available on the announcement section. Thank you very much. Enjoy your day.